Hello viewers, I am Dr. Simranjeet Kaur Gill, Professor of Law from City University, Ludhiana, here to present the third topic on nature of jurisprudence. Jurisprudence is the study and the theory of law, and it plays a critical role in shaping our understanding of the legal system. This field provides insight into the fundamental principles and concepts of law, including the meanings of rights, duties, possessions, properties, and remedies. By examining these concepts, jurisprudence helps us to better understand the role and function of law in society. The nature of jurisprudence is similar to science. It is not an art. In fact, it is progressive science. Jurisprudence merely does not connote the understanding or grasp over the law. It covers a field much wider than this. Jurisprudence does not contain any set ideals and postulations, nor does it have any practical application. It has not been acquired from any authentic and factual source. Stallman puts that jurisprudence is the subject different from all other subjects of the law. Subjects like law of contract, torts, and evidence consist of a set of rules derived from authoritative sources and are applied to the factual situation in order to solve the practical problems. However, jurisprudence does not consist of a set ordinances and precepts. It is not only derived from any authoritative sources and is without any practical application. In other legal subjects, we look for a rule relevant to a given situation, whereas in jurisprudence, we ask what it is for a rule to be a legal rule and what distinguishes law from morality, etiquette, and other phenomena. In this sense, jurisprudence comprises the philosophy of law. Patton has rightly said regarding the nature and the scope of the jurisprudence that modern jurisprudence treads on the field of social sciences and philosophy. It gets deep into the history in order to create the symmetry of the garden out of the luxuriant chaos of the clashing judicature. He has also said that jurisprudence is the specific procedure of the study of the prevalent notion of the law. It's not the law of any specific country. Julius Stone explained it very beautifully. He has put forward the nature of jurisprudence by saying it's a chaos of approaches to the chaos of topic, chaotically determined. One of the key aspects of the jurisprudence is its focus on the sources of law. This field provides insight into the various sources of law, including statutory law, common law, and constitutional law. Through the study of the jurisprudence, the scholars and the practitioners seek to develop a deeper understanding of how these sources of law interact with each other and how they influence the development of the legal system over the time. Another important aspect of jurisprudence is its role in clarifying the concept of law itself. While the law is often thought of as a set of rules and regulations, jurisprudence helps us to understand that law is a complex and multifaceted concept that cannot be reduced to a simple definition. Instead, the law is a dynamic and evolving concept that is shaped by the range of social, cultural and political factors. It is important to note that jurisprudence is not a substantive or procedural law. Rather, it is an uncodified law that provides a framework for understanding the legal system as a whole. Jurisprudence serves as the eye of law, providing insight into how the law operates and how it can be used to achieve justice and fairness in the society. Jurisprudence analyzes legal concepts. It also tries to find out the essential principles of law. It is not only the analyzes the rules which are already known, but it also analyzes and sets the foundation of new rules. It is a result of the thinking of the jurists and the philosophers. They are having the freedom to assess, analyze and speculate about the legal system. So, it can be said as an intellectual exercise which is having no immediate practical application. It sets the tone for a reformation of the law. Jurisprudence links the law with other disciplines like psychology, politics, economics, etc. Its scope is always changing. It is not derived from any act of parliament or state assembly. Lord Tennyson calls it lawless subject of the law. Various concepts like origin of law, need of the law, the utility of law are studied by the various jurists. This study of concept of law is called jurisprudence. Branches of jurisprudence: historical jurisprudence, analytical jurisprudence, ethical or philosophical jurisprudence. If we discuss briefly what historical jurisprudence is, it deals with the general principles governing the origin and development of law, with the influences that affects the law, with the origin and development of those legal conceptions and principles which are so essential, their nature, as to deserve a place in the philosophy of law. Knowledge of past is essential to appreciate the present legal system and resolves the flaw therein to devise better laws for changing society. Jurisprudence and history are interlinked. Study of jurisprudence includes study of history in order to better understand the culture and custom of a society, background of a statute and its objective, context of a precedent, etc. History helps jurisprudence to go deep into origin and evaluation of different legal terms. The whole historical school of jurisprudence is dedicated to analyze law in its historical perspective and has immensely contributed to trace the evolution of law and legal systems in different countries. For example, the codification of the Hindu personal law in India was a result of the historical analysis of the uncodified Hindu customs and practiced norms of the ancient India and its transition throughout. Analytical jurisprudence: those thinkers of jurisprudence who regard law as a command emanating from the government or from the state as the political organization of the society and who treats the relation of law to the state as its most important aspect, may be grouped in the analytical school of jurisprudence. They are mainly concerned with the definition of law. In fact, the purpose of analytical jurisprudence is to analyze this without reference either to their historical origin and development, to their ethical significance or validity of the first principle of law. John Austin is the leading exponent of this school. It analyzes the first principles of the law as they exist in the legal system. Examples, rights and duties, etc. Ethical or philosophical jurisprudence deals with ethical significance and adequacy of law. The purpose of the legal theory, law as a dictate of a reason, the idea that in reality law consists of rules in accordance with the reasons and the nature has formed the basis of a variety of the natural law. Theories ranging from classical times to the present day. Natural law also serves as a defense against ethical relativism. Indeed, the idea of the natural law originated in answer to a philosophical theory challenged the obligation of all human rules and even of law itself. If we talk about law as a command of the sovereign, imperative law, it distinguishes the question whether a rule is a legal rule from the question whether it is just a rule, and seeks to define law not by reference to its content but according to the formal criteria which differentiate legal rules from other rules like moral etiquettes, etc. Law as the practice of the court. Legal realism like Austin, their realist looks on law as the command of the sovereign, but his sovereign is not the parliament but the judges. For the realist, the sovereign is the court. Law as a system of rules. Rules are concerned not with what happens but with what ought to be done. They are imperative and prescriptive rather than indicative or descriptive. Rules differ from the command in their generality, whereas a command normally calls for one unique performance. Law as international law. The stand taken by the international lawyer is to reject the Austinian's definition of law, to deny the necessity of a sovereign and sanctions, and to propose a definition of law wide enough to include international law, because according to Abraham, law was defined as a body of rules for the human conduct within a community, which by common consent of this community shall be enforced by external power. But it lacks certain important features of standard legal system, such as legislative organs, courts with compulsory jurisdiction, and institutionalized method of law enforcement. Philosophical jurisprudence. Exponents of this school of jurisprudence were mainly concerned with the relation of the law to some set of idea or ideas outside the law. Among such ideas, that the purpose of the society is to make the men virtuous, and such is the purpose of the law, that the end of the law is to maintain justice in the society. The legal restrictions can be justified only insofar as they promote the freedom of individual in society. Kant, that the end of the law is to promote the greatest happiness of the greatest number. Bentham. In short, the school is primarily concerned with the principle of ultimate right and wrong. If we talk about sociological jurisprudence, the sociological jurisprudence is chiefly concerned with the relation of law to contemporary social institutions. It is still in the making. Jurists like Pond, Herring, Elric have adopted this method for the study of the legal philosophy. According to these jurists, the essential characteristic of law is that it shall prevail, that it shall actually represent the common interaction of men in their daily life. This classification of jurisprudence provides a rough classification of idea, and it is not proper to limit the scope of jurisprudence. On the basis of this classification, with the changes of social, political and economical outlook, and with the changes in the conditions of individuals and national life, much may come under the province of this science of law, namely jurisprudence. Thus, we can say that whatever the nature of law or the working of authority or the analysis of legal concept of jurisprudence should not confine itself to logic. Legal theory is concerned with the law as it exists and functions in the society, the way in which law is created and enforced, the influence of social opinion, the effect is the effectiveness of law, and the part played by the sanctions are all points where jurisprudence meet other disciplines such as sociology, psychology and so forth. One task of the jurisprudence is to link the law with other disciplines and to help to locate it within its wider social context. So, in analyzing legal concept, we must try to present them against the background of the social development and changing economical and political attitude. Jurisprudence of human rights and humanitarian law. 21st century witnesses huge change in the protection of the scope and concept of jurisprudence. Jurisprudence of human rights and humanitarian law has literally shaken the world so far as the interpretation and evaluation of human needs and interests are concerned. In search of global democratic order, two concepts, human rights and humanitarian law, have emerged as important theory of practical jurisprudence. There is no doubt about the fact that humanity is indivisible and the law, for so long as it is meant to serve the life, must have common feature and applications, nationally and international. The Universal Declaration of Human Rights accord recognition to the inherent dignity and inalienable right of all the members of the human family as the foundation of the freedom, justice and peace in the world. The humanitarian context of the Bill of the Human Right is brought out in the Universal Declaration, which condemns disregard and contempt for the human rights, which have resulted in barbarous acts, which have outraged the conscience of mankind. Thus, the basic value is the dignity and the worth of a human person, which is defended by the twin branches of universal norms, manifested in the humanitarian law and human rights. Indeed, as we study the international law instrument, we perceive certain declarations and conventions against torture and other cruel, inhuman or degrading treatment or punishment. There is a great area where two branches of the law overlap, although more stress is laid down on a human rights than on the humanitarian law. In one sense, humanitarian law in its global sweeping semantic will embrace the large part of human rights. Strictly so called, it is the manifesto of the human person that matters, whether in war or in peace. Jurisprudence of juridical strictures. Indian judiciary is known world over for its contribution and activism. Of late, question is being raised about the role of judges, particularly in the context of judicial structures. honorable judges speak through their judgments and also at times by off the bench in addition to day-to-day questioning and making comments during hearing to the cases. It is very difficult to define the term structure and strictures. It is also difficult to decide the code of ability which should be maintained while making any comment by the honorable judges in the different courts. The plural facets of the structured jurisprudence have been pointed out by Mr. Justice H.R. Khanna. Those are: criticism of judiciary should be constructive and not destructive. Must it aim to rehabilitate the judicial system and not to deliberate it? Judge is not free like a loose cannon to inflict indiscrimination damage whenever he announces that he is acting in his judicial capacity. Judicial choice between epic, ISM and socialism is not consensus. Strikes a judge who makes his position in a court to mere pretext to condemn another person for personal reasons does not act as a judge at all. He is merely party who has arrogated to himself the position of a judge. Judicial restraint and disciplines are as necessary to orderly administration of justice as they are to the effectiveness of the army. The duty of the restraint and humility of the function should be constant theme of our judges. This quality of decision making, it as much necessary for the judges to command respect as to protect the independence of the judiciary. Respect to those who came before the court as well as to the other coordinated branches of the state, the executive and the legislature. There must be mutual respect. Where these qualifies fail, or when litigant in public believes that judge has failed in these qualities, it will be neither good for the judge nor for the judicial process. Jurisprudence and the legal theory are two related but distinct fields of study. Jurisprudence is a broader field that encompasses the study of the nature of the law and its principles, while legal theory is a subset of jurisprudence. This specifically examines the philosophical content of the law. The Fitzgerald has pointed out jurisprudence covers a wider field of studies compared to the legal theory. It involves an investigation of abstract, journal and theoretical aspects of the law. In contrast, legal theory seeks to clarify the most fundamental legal concept and answer the question, what is law? Legal theory is just one aspect of the jurisprudence which is concerned with the evaluative and philosophical study of law. In terms of its end, values and goods, it is focused on living law, which is based on the social forces and felt needs, and it rejects purely technical, analytical or conceptual perceptions of the law. In summary, jurisprudence is a broader field that encompasses legal theory as well as other aspects of the study of the law. Legal theory, on the other hand, is a subset of the jurisprudence that specifically focuses on the philosophical content of the law. In concluding remarks, jurisprudence plays a crucial role in the development of the legal system and the society, as it provides a theoretical framework for understanding the law and its underlying principles. Through jurisprudence, we gain knowledge about the basic principles of law and the sources from which they are derived. It helps us to understand the legal system of different countries and the culture social and economic factors that shape them. Furthermore, jurisprudence is not just a theoretical abstraction, it has practical implications as well. It provides guidance to the lawyers, judges, policymakers in making legal decisions that are just and equitable. Therefore, the study of jurisprudence is essential for everyone who wishes to understand the law and its role in society overall. Jurisprudence is a fascinating and multifaceted field of study that holds much importance in the vast field of law. It is a subject that requires deep critical thinking and analytical skill, as well as broad understanding of the social, political and economic context in which the law operates. Thank you viewers for watching this program.